following program on Other Derana 24 is classified for general audience. It is intended for all ages. It contains little or no violence, no strong language, and little or no sexual dialogue or situations.
Tonight, we discuss Sri Lanka's provisions for the admission of evidence in the court of law. A rise in criminal cases has taken a more central role in Sri Lanka's public discourse in the run-up to the new year. In a recent murder incident where a high-profile individual was assassinated, the question rose as to the novel forms of evidence being recognized across the world and how it can be used to further the cause of justice, especially in Sri Lanka. Is our justice system geared to make these changes? Where are the key reforms required? How well does the process of evidence admission work within Sri Lanka? Welcome to Law, Land and Liberty, where we're keeping with the promise of bringing in a contemporary legal topic and breaking it down for our viewers. Now, something that has been within our discussions within the public forum as of now, and which is what we gave in our introduction as well, is the law of evidence, which in particular is related to some criminal cases that have been occurring within our country, especially with regards to a high-profile case that have been taking up the airwaves for quite some time now. A lot of breakdown that is required when it comes to the law of evidence, because it is a vast subject and it has been improving, have been being amended within the world and within our country for quite some time. So these nuances are some things that people need some ironing out, some form of clarification. And for that we have with us an individual who has a lot of experience within this field and is doing us and has given us the privilege of having a conversation with him. President's Counsel, Prasanthalal, Alwis, thank you so much, sir, for joining me today.
Privileged to be here.
Thank you, sir. He's a lecturer in criminal law amongst many other accolades, I think, which will take a long time for us to really list out. But we will get into the experience and we'll get into all of that within our discussion, sir, and I think there's a lot that we can talk about. Now, as usual, what we do within this program is we give a breakdown to our viewers about what exactly is going to happen within the discussion so that anyone can have a brief idea of where we are going to go with the discussion. In order to do that, our first topic will be on the evidence ordinance, where we'll discuss the fundamentals with regards to evidence law within our country. Secondly, the admission and collection process of evidence. Thirdly, the regulations related to witnesses. And finally, the new forms of evidence identified and reforms within this area.
Hi, my name is Tanedu and I am a management undergraduate. My question is on the evidence ordinance. What are the key provisions in the evidence ordinance in Sri Lanka?
All right, let's get into the discussion directly. Once again, sir, thank you so much for joining me on this program. We hope to have a fruitful discussion and maybe even in the future have a lot more to discuss pertaining to ethics and the entire profession of our legal system, which is something you have been contributing for quite some time now. So today's topic, the law on evidence, and beginning there we can start actually. Anyone would point their fingers towards the evidence ordinance. My first question to you, sir, would be, is that approach correct to this topic? Is that where we start? And if possible, can you let us know the other legislation that are part of the evidence ordinance that are coming as sister regulations, which are involved in the entire evidence collection process, the admissions, the submissions and all of that? What are the key laws that are in play?
The basic key laws are is the evidence ordinance, as you mentioned, which came into being in 1895, long time ago, more than 125 years. Now that was brought in by the British naturally when you look at the year. And it came from the British tradition, which was not legalized, not written law, but then came to India. And if you take Indian evidence ordinance and our evidence ordinance, except for section 27, it's almost identical, even the numbering is same. So that's a history of evidence ordinance, Danidu. But then the whole development took place with audio and video visuals, and also computer evidence. In that, in 1995, Act number 14, Evidence Ordinance, Special Provision Act came into being. So we have, as far as Evidence Ordinance is concerned, this enactment, which has 167 sections, but I like to stress here, this covers both civil and criminal law. Because if you take the Criminal Procedure Code, that has section 458, which came into 1979, that covers the procedure of the criminal law. And the Penal Code is where the major offences are described, which has about 490 sections. All has a history similar history
Right.
that came from the Britain. So 1995 is the edition, I believe I can say, the only addition to the evidence ordinance that has come. After that, several amendments had come in, but very few in number, because this has found a very strong place in the adversarial system of justice done. We don't believe in an inquisitorial system in the Commonwealth countries. There are rules which are here in this evidence ordinance. Evidence are brought in or out according to the adversarial system. Judge, and the system is like a umpire, football umpire, cricket umpire. Like test cricket, this would be a wide, but in T20,
it will be different.
It will be totally different. Likewise, here it is rule-based. So our system is adversarial, it's rule-based, and it is evidence-led. So the prosecutors, investigators has to think of this one when they are collecting evidence.
Now, let me just unpack that. I think you gave a very good introduction to what we are going to talk about today, but let's unpack that with separate elements itself. Now, the comparison that you made to cricket, so I think is very important there, because not only in the inquisitorial and adversarial system, but when it comes to civil and criminal legal, the processes also, is there a difference when it comes to evidence? Because now we see the burden of proof changing vastly, and cases, the similar cases would be judged in different ways. When it comes to the admission of evidence, what is your take there, if you can, I think, start
there? It's very interesting question, that because when you take the prosecution case, when the moment accused plead not guilty, you are presumed to be innocent. So the burden shift to the prosecution. I have been a state counsel for 7 years prosecuting. My role was to establish the two elements, action, actus reus, and the mens rea, the mind element in most of the penal code offences, beyond reasonable doubt. Now that means doubt without a reason. Now there is a heavy burden therefore on that. But the civil basis is balance of probability. Like the scale what you see in our Athena. She holds a sword, and in the other hand you have a scale done, and that means what is the balance? What is more probable? Now that is there in the civil. But I like to stress where the accused has to present a defense. That is in chapter 4, like insanity, intoxication, or whatever mistake of fact, that the accused has a very better advantage. He only has to prove the case beyond, not beyond reasonable doubt, on a balance of probability. What is more probable? So that's an advantage to the accused. Our system is more tendency, entire process, we can discuss further, is more towards the accused rights.
I think within our last segment, I want to ask you about the moral and the practical aspects of all of this, because we want to talk about reforms and everything. So just going into the most updated version of the evidence ordinance, I believe you said there's only one key edition that came out after the initial enactment. Before, I don't want to like bleed into the other segments, but before we go into anything, does this encompass, because you're a practitioner, you can answer this, does this encompass the areas that we are facing right now? Do we have the tools to really engage with the kind of cases that are happening right now, especially with regards to this case that has taken the entire country by surprise? Without going into the case facts of that, do we have all relevant legislation in place, just to get a briefing on that?
Yes, again, as we discussed at the beginning, we are not inquisitorial system of justice. What is inquisitorial system of justice is till the end of the process, you are trying to find the truth. What is truth? And that's the process.
And the judge plays the bigger role there.
Exactly, active role in finding the truth. Like you can see in some movies, in Hindi movies or English, you suddenly come at the middle of the trial, a witness comes out and says, this is how it happened, then that is taken. But in Sri Lanka, we cannot. So first of all, we have to look at whether we need to change this system. Because as you mentioned, it is evidence ordinance and the legal practice says beyond reasonable doubt. The new change is happening, which is called Elembaro principle, which says if the accused is led with a prima facie case, and if he knows some facts, he has to come out with it. Now that's some new development in the world, where it's not only beyond reasonable doubt, if there is a prima facie case, that's the understanding, against the prosecution, by the prosecution, against the accused, then accused must lead some evidence if it is within his knowledge. If it is within his knowledge. So that's an interesting trend that is happening. As our courts have, in few cases, has adopted that. But sadly, regrettably, it has not found it a very strong ground.
Right. So I think just to make a comment on that, I think now we can like proceed into the aspect of evidence and talk about the various elements there. But parallel to the Fifth Amendment, I believe, within the United States, is present in Sri Lanka as well. If I'm not mistaken, within our criminal code, I'll just quote out the section as well, pertaining to a party that is a witness not having to incriminate themselves when it comes to the court of law. Does that exist, or how does that aspect work within our criminal justice?
It is. Generally, you are not supposed to incriminate yourself. We call it a privilege against self-incrimination.
Yeah,
and
exactly.
that system, that concept is very strongly in Sri Lanka, established in all the rules of what we have.
Yeah.
So that is there.
No, just to connect
not
that to
as a section.
Yeah, just to connect that to what you were mentioning before. So, like, if the accused knew, how does that work together? Like, if the accused knows a certain information, he is required to.
Only he is aware.
Right.
Okay. Then his burden is on him to explain.
Right.
Because if there is a judgment to say mass of evidence against you, that is a prima facie case. The accused must then say, hey, I know this is my part.
Okay.
So he have to come out with it. Earlier it was not the case.
Not the case. Right. Just moving back to the legislature that we wanted to talk about, sir. Let's just to unpack a few of the definitions that are in play. Now, evidence, the concept of evidence, looking through the lens of the criminal justice system. What exactly is encompassed under that wording? What would be, is there a basic definition that has been provided, a working definition maybe that already is like in play when it comes to cases? Or are there improvements? Are there other sort of sub-elements that say, okay, these are the things that are ruled out as admissible evidence? If you can unpack that for us.
Yes, in our legal evidence system, there is two words, relevant and admissible. Right. So we have to be relevant to the case. Okay. You can't bring all irrelevant thing into the case. Now that is defined in very clearly in our evidence ordinance from section 5 to 15. Yeah. So that is relevancy, that is logical. Yeah. It's based on a logic, why it is like motive, subsequent conduct, previous conduct, and whether it is against the fact in issue, which is contrary, like an alibi. You say that I committed the offense here, but I say at this moment I was somewhere else. So those factors are relevant. Yeah. Now that is there. But even if it is relevant, unfortunately, I believe, I'm using the word unfortunately, it may not become admissible. Okay. Good example, if you come to my home and I kill you, only evidence is my wife. Yeah. My wife evidence can't be laid against me. Okay. Because that's under section 120, privilege. We want to preserve the privilege.
Spousal privilege.
Yeah, exactly. We have to preserve the marriage life. Yeah. We can't force a wife to even to lie for me. Okay. So, and therefore they shut it out. Now, very interestingly, why it is not logical is, say my son is there, that is admissible. Okay. Now that seems to be illogical. That's my own product. Now, if it is the logic is to preserve the marriage, and the logic is not to for that person forcing him to lie for me, then how about my kids? So it seems to be illogical, but that is admissible. That is section 120. Okay. Unless I hit my wife or I hit my child, then of course that is admissible. So it's very sometimes it is policy based. But then it is not sometimes not a valid logic.
Sure, I think that makes sense because there's a lot of public policy involved in this specific field. So just moving on with the points that you were making. Now the issue of relevance. How exactly? I think you brought in an example which really like sort of irons out a lot of the issues that we would have pertaining to it. But how is relevance really judged in terms of a case? Because I believe certain elements of evidence are summarily heard and decided on whether it will be relevant to the case, and that's something the courts are strict about what we'll be discussing throughout the trial. How does the issue of relevance come into play? What is the optics of the judiciary when it comes to that specific issue?
It has to be within section 5, which is fact in issue, and the relevant can be laid under 5, 6 to 15, and thereafter too, like the expert opinion, it is relevant. Though it is an opinion, we can discuss further later. Yeah. And the confessions are not, some are admissible, some are not.
Yeah.
So those are to be decided by the judge,
Yeah,
whether it's
yeah.
relevant or not.
Right.
Except in a jury matter, very interestingly,
Okay.
the legal issues are judged by the judge. They will send the jury out. But sadly, in today's context, it is the jury system. The accused has a right to select whether he wants a jury or not.
Yeah.
So you don't see hardly, when I was prosecuting, it was all murder, rape cases were jury trials, but not anymore.
Okay.
You hardly see a jury trial, which is beautiful. I mean, it's logical because it's 7 of your peers, 7 common people who will decide whether you actually committed the offense or not.
Exactly.
So that is nothing, not to be seen much nowadays.
Yeah.
Which I believe I'm sad about it.
Yeah.
So that's how it is.
Yeah, I think that's a very interesting discussion we can have maybe towards our last segment. As a last question within this segment, sir, I want to ask you, the issues of relevance, the issues of admissibility, how does that work in a civil case? Is it the same? Did you explain it in both ways? Or
Yes, it is. It is.
Right.
As I explained to you, this evidence ordinance is relevant to both civil and criminal.
Right.
And admissibility too.
Yeah.
Of course, admissibility, interestingly, as I mentioned, the confessions and all this wife against the husband, all that is in a criminal proceedings.
Right.
So
Right.
there is a vast difference in bad character.
Yeah.
In a civil matter that can be led, but not in a criminal case. So likewise, there's a huge, as you posed the question, huge distinction between a civil and a criminal case.
Right. I think that really opens our window to the next few segments that we want to discuss with you. I think a very fruitful first section that we just discussed. Stay with us on Law, Land and Liberty as we continue this discussion.
And I'm an AM in shipping industry, line and operations. So my question is on evidence admission. What are the laws that govern the submission and collection of evidence by the police?
Welcome back to Law, Land and Liberty. We are in conversation with President's Counsel, Prasanthalal, the Alwis. A very important first segment that we passed. I think you laid the foundation to where we are going to take this discussion. Sir, on this segment, admissibility, as you really pointed out, and relevance are the key indicators, one would say, that really gives sort of like a window into what evidence is actually presented to courts. Let's talk a bit about that, and let's unpack that in reference to the evidence ordinance as well. Where do we begin in terms of what sort of evidence becomes admissible at the end of the day, and what sort of evidence becomes relevant? And from that point onwards, I think we can develop on it.
Yes, as we discussed in the first segment,
Yeah.
it is everything has to be logical to be relevant,
Right.
logically connected to the fact in issue, whether you killed a person or not, whether you raped a person or not, you stole something or not.
Right.
It has to be relevant and logically connected.
Okay.
So that's about relevancy.
Okay.
But then admissibility is based on policy, as we explained. Good example would be confessions.
Right.
Now admissions, very interestingly, that means confession, I'll make that distinction first.
Yeah.
Confession is only relevant to criminal law.
Okay.
Where I say to you, Danidu, that I killed my wife
Yeah.
in person. Now that's a confession. I'm confessing that I killed my wife,
Yeah.
right? But then I committed adultery with another woman.
Right.
Now that's not a crime. That is an admission.
Right.
So
Okay.
admission can be led against me,
Okay.
very easily, unless, of course, it's about my own. If it is not in my favor. I mean,
Okay.
otherwise, if admission is in my favor,
Yeah.
I can always make a lot of admissions for me to be, not culpable in
Yeah.
a civil matter.
Yeah.
So that's a basic rule of admission.
Okay.
There are several rules, Tanidu, in the field of criminal law, which is fascinating.
Right.
To shut out what you mentioned earlier, privilege against self-incrimination.
Right.
Right, because the law does not allow, or law does not allow in an adversarial system to use a confession against you,
Right.
so that police will naturally and inevitably, that's what's said in Buddharakkhita, those are 2 monks' cases,
Right.
that the police will use hard force, so that rather than investigating separately, finding out independent evidence, they would rather then go for a confession. which they wanted to avoid. So they shut out confessions completely in some instances.
Right. Just to harp on that a bit more, so, but we do see the issues of confession coming into light. I think the media also should take a certain amount of responsibility with pertaining to that, because it becomes a conversation in public discourse. How it came out isn't really given to the public, but rather the confession is what's being put out. So a misdirection there could in fact occur. I think you really pointed out the aspect of why this is something that I want to clarify for our viewers also. In police custody, when there's an admission or confession that is made, that won't be admissible to courts. Is that what we need to understand firstly?
Yes, there are two instances.
Right.
If you make a confession to 3 officers, that is police officers, excise officers, those are about, liquor, illegal liquor and all that, and forest officers. Only that 3 confessions is shut out. Okay. Now, if I make a confession to the Consumer Affairs Authority officer, or a public health inspector in a case, or to custom officer for that matter, which is all criminally implicated, or even in a mosquito breeding act against that to a PHI, as I mentioned, all those can be led only against the police officer, excise and forest officer, which I feel which is not, no logic behind that. Why only limit to these 3? So any event.
So what is the logic there, so as in like just to get an understanding?
If you analyze all that era, it was only excise officers and the forest officers who have been major in prosecuting and investigating. So probably they limited, but then our law, we could not develop further on that to include these interesting areas if they want to. But then confessions are totally shut out, but we can discuss whether it is true or not. It is just merely technically shut out, which I don't think it is the right approach, because that is adversarial system. Whether it is truth or not doesn't matter. Just making a statement to the police is enough. Second thing is much more worse to me, and that is, say I'm in the police station and you come with a rice parcel for me and I tell Danudu I kill my wife. That is out. Now that is a total independent person. Your evidence is very independent. But if I am in a police custody, excise custody, forest custody, then the evidence gets shut out. Now that seems to be from the truth point of view, which is should be the whole exercise, whole purpose of criminal justice is merely shut out. But if I tell you at home, similarly, when you visit my home and I say today I killed my wife, I'm just giving an example, right? That is admissible. But not while I am in police custody. So these things has to be sorted out, and we have to make changes because British law has changed a lot. They have changed far, but we still remain, India and us, still keep this whole archaic law intact.
I think that's an area that I want to dive deeper into. But before that, sir, just to talk about, we spoke a lot about the verbal aspect of everything, the admission of evidence when it comes to that. But there are multiple other elements. Now, let's just take a few more pertaining to proclamations, as in someone maybe writing something down or a letter that is being admitted, and now in our cases the social media aspect is involved. How are those elements of evidence involved in this scope? Do we have to make improvements there? What is admissible? What is considered relevant?
Yes, you're referring to documents and audio, video and compute evidence. So this is very interesting. Now, in the good old days, the entire thing was based on documents. So the original had to be brought to court, so wherever it is. Not even a photocopy, unless the original is destroyed or cannot be brought in. That kind of a scenario, only we call it secondary evidence can be led or destroyed, kind of a scenario. So then otherwise we have to get the original to courts. Right now, what is the original in a computer evidence? You just get a printout. So we have to change with the system now. That we have made under Computer Crimes Act, Payment Devices Fraud, that is credit card, and Electronic Transaction Act, all came in year 2006, 2007, that period. And by now it has become accepted as evidence rather than the original document. Mere affidavit from the person who is handling the computer is good enough nowadays. You don't need to say that is a truth evidence. But very interestingly, under the Special Possession Act that I mentioned in 1995, you have to give 45 days notice to the other party.
Okay.
Because what you mentioned, because this can be fabricated. Social media can be fabricated.
Exactly.
They can manipulate things and do that. So that gives a 45 days notice to the other party to come and verify. But I want to stress, Electronic Transaction Act that came in 2006 does not allow that 45 days notice. So that safeguard is no more if it is an electronic transaction. Like most of the transactions now are electronic. You saw in COVID, most of the transactions occurred through electronic transaction. I mean, you order food, whatever thing that you order, from a virtual media, that is electronic transaction. So there is a great lacuna there because there is a check and balance. Of course, there is always a right for the other party to challenge it. But that 45 days notice that was earlier given for computer evidence, audio evidence, video evidence still is not valid when it comes to computer evidence, electronic transactions. But audio video like CCTV cameras is still valid, because I like to stress here in the future, this ordinance to me would be archaic. It is like a dinosaur. Very good, very comprehensive, but because all is handled through CCTV now. If you take CCTV news today, accidents, which is very complicated. Who is rash? Who is negligent is a very crucial factor, because it happens in a split second. And eyewitness, if it is you are depending on eyewitness, is very difficult to say how it happened. But today's context, you have CCTV camera, most of it. Accidents, you can see that very clearly. We can say who is rash, who is negligent. So entire future will be CCTV cameras. And I was in the Ramukkana shooting accident, a thing appointed by the Human Rights Commission. It was entirely about CCTV footage that we came to conclusions about. Of course, before that we had to rely on Moratuwa University to see whether they are fabricated or not. But what I want to stress here is the future. All what we spoke of, relevancy, admissible, would be not in existence. As I said, the big dinosaur, very nice concept, very valid concept, would not be there, because CCTV footage would be that. So you can see in the recent past, people preferred to take people to places where there is no CCTV footage, right? So that the whole evidence is lost. So it's very interesting, this kind of scenario.
So just to develop on those things now, let's take the aspect of this tangible sort of evidence, so like fingerprints, crime scene investigation. Basically, I want to get your take on that, about the collection of evidence there. What are the regulations that are in play? What are the aspects of saying, okay, this is the mandate of the investigating officers, which is mostly the police in most scenarios that we witness in criminal cases? What are the other, if you can just give an outline of the institutions that are there and the regulations that are in place for, particularly when it comes to crime investigation, crime scene investigation?
Absolutely. It is now the whole DNA evidence is the most critical factor. If you take our Justice Ambe Pitiya was killed, it's now, entire matter is concluded. It was the vomit that was there at a hotel, man vomited, and you take the DNA and you compare. And then that was a critical factor. So you can see DNA will play a major role in the future, but DNA cannot be contaminated. So the investigation has to be extremely careful about this contamination, otherwise the whole thing is invalid. So DNA will play a very vital role. But as you said, fingerprints, now you saw in recent past, they were taking fingerprints of in a car or whatever, because fingerprint is something unique. Now my fingerprint cannot be found in any other place. Say I plead guilty in a case today, if it's a penal code, my fingerprints are taken and sent to Colombo, and they will say, I have a lot of previous convictions, and therefore I am a IRC or island reconvicted criminal. Now that kind of thing is there. A very positive thing about fingerprints, footprints, which is very unique to me. So that has developed very critically, very fast again. So that will be vital in most of the cases. But unfortunately, we have to arrest the accused in order to match the fingerprints in a car or someplace that offense committed. So if we don't catch a person, then this is merely only a fingerprint, unless he is a hardcore criminal who is already in the system. So that is something.
We need something to cross-check that.
Exactly. So this will be interesting development that has happened. And today, telephone, now if I am using the mobile, and that is tracked, my whole tracking can take place. That's how Justice Ambedkar's case, the people who conspired was brought into justice simply because of the movement of a telephone, movement of a mobile phone.
Right.
So likewise, these are very critical factors today.
Yeah.
The science has developed so much, technology has developed so much.
Yeah.
So in that kind of a context, we will find accused unless they have planned very carefully not to be in a CCTV area where they use a person who is not with fingerprints in a normal system.
Yeah.
So it will be very, very interesting.
Right. So I think as you explain it, it's quite sophisticated, but at the same time it's comprehensive.
Yeah.
And we are seeing a lot of developments that really need to take place when it comes to this. Just to get a final question through for this segment, sir, we were talking about the mishandling of evidence, as in the contamination of evidence. So you have been on both sides of the aisle when it comes to criminal cases, so you can really explain this to us well, pertaining to where the lines are drawn about how evidence is mishandled or how evidence is maybe contaminated, because this is not only in criminal cases, as in just developing on criminal cases, things like the excise issue that we were talking about when it comes to drugs or any of that sort. There are certain volumes that you're talking about and that should be kept, that should be dealt with properly, safely, and should be consistent throughout these cases. Where are the lines drawn pertaining to what a police officer or some individual can do? Is it governed under the evidence ordinance, or is it separately under how the mandate of a police officer or investigative officer is governed? Is that separate? Is that coming under our discussion?
Yes, that is very important. Now this is evidence ordinance which governs trials.
Exactly.
Now the prosecutor, a good prosecutor, should understand what are his limitations, what are the safeguards he must do in order to get a good conviction. He might find a person. Right, now good example, Saya's case, the small girl was this. There was a confession by the brother who finally got convicted. A brother, apparently that confession was the one that was used in the media and all that, and later found that it was not the case. Fortunately, the truth happened later because of scientific development that has taken place. Otherwise, we would have probably convicted a wrong person. Right, so therefore, the investigator has to think of the law here, because we are adversarial system, and then go accordingly. Like good example that you say, now say we find a certain productions in a place that has to be kept in a very safe place. It can't be touched by anybody else. If it is DNA, is going to be the use. And that line, the police officer who took that to the government analyst, and all those has to be led in evidence in the trial. The whole line has to be really established so that it is not contaminated. The whole process has been done properly. So the investigator plays a vital role in the final conviction, because that's what matters. And that's what now as a defense counsel we use
I think
in order to get acquittal.
Exactly. So I think that sort of explains the kind of burden in terms of these institutions as well. I want to dive deeper into that as well. We'll take a very short break. We are in discussion with President's Counsel Prasanthalal, Alwis. Stay with us on Law and
and I'm a business developer. My question is on witness admissions. How is evidence from the witness administered in the court of law?
Welcome back to Law, Land and Liberty. We are in conversation with President's Counsel Prasanthalal, Alwis. Sir, two very important segments that we just passed, and here I want to talk about the witnesses aspect. And please just direct the conversation to areas that we haven't really gone into and that you believe the people need to know about. Just keeping this segment a little short, I want to get an identification. Now, witnesses are also used to bring in evidence, and more often than not, it's through their senses, basically what they see or heard, or whether they were in a particular place at one particular time. How is that exactly governed? So who is allowed to give witness? Are there regulations there? What are the limitations pertaining to what a witness can say or not do? And if you're just taking a step further, what a prosecutor or even a defense attorney is allowed to ask from one of these witnesses when they're put on the stand. If you can give sort of like a elaboration of all of that, I think our viewers will find it very interesting.
When a witness gets into the box, we have to understand he will be cross-examined and be re-examined. So cross-examination means you can lead, prosecution can't lead evidence. What you mean by lead evidence is getting posing a question where yes or no. So here narration has to come in. And unfortunately, when I was a state counsel, we can't speak to lay witnesses. That's the tradition.
Right.
So I found as a young state counsel very frustrating sometimes because we are leading a witness that is there. But that's a good tradition, because otherwise I may tend to coach a witness in order to get a conviction, because Attorney General is supposed to be independent and therefore he cannot speak to them. So it's a debatable, but that's how it is regulated. So when you are cross-examining a witness, then the other party get another right to re-examine a witness. That means arising from cross-examination, if there are any creating doubts, then re-examination, the other party can re-examine. Now, a good example is about a case where Goyang Kole Goyang Kole. Now, Goyang Kole to the foreigners at that time, there are two interpretations, simply Goyang Kole and the whole batter. Now, there the re-examination state counsel, who is a Britisher probably, he could not clarify what it is, right? What is Goyang Kole? Now that is where state counsel have to be alert. What is this defense counsel is moving on? And with poor witness he is unaware. He would say merely Goyang Kole to Muavela cover. I got covered. Now it is the duty of a prosecuting officer at that point to clarify those. You can't blame the system for it. There is an opportunity for re-examination. People blame the system and say, people can get acquitted on these kind of things, which is not right, because there is an opportunity for re-examination. So likewise, there is a lot of rules, as I mentioned, small child. First, if his evidence led, there may be the only small child who is giving evidence. So our 118 says the small child need to understand. The judge must make sure that he will understand the question and give an answer accordingly. A reasonable answer to the question. So there is a role in a courthouse, if there is a small child involved, a process to verify whether the child understands the question and give a reasonable answer to it. So the judge will ask, what is this, what is the color of this, and kind of few questions which is recorded, so that the judge verifies whether it is so. So there are a lot of safeguards to make sure that the best witness comes out. Good example, we cannot ask from a witness bad character of the accused. So I can't ask is he a murderer? Is
it unless it's relevant to the case, or not at all?
Not at all. Unless it shows a motive. Now, say the accused has raped a girl and the girl's father killed the other person, or whatever it is. If it is relevant to the motive, yes, but otherwise you can't say he's generally a criminal, he's generally a thief, because the law system says we cannot have prejudice against the accused in a trial. So that's the objective. Main thing is no prejudice to the accused. As I said before, our law is more tendency towards the accused rights in our criminal law system, which some people argue right. But if you want to have inquisitorial system, if you want to find the truth as an objective, then there is a question mark whether we should have all these laws for the accused. So it is something that which is very vital, which there are a lot of safeguards. As I mentioned, witness can refresh his memory through notes that he made at that time. So all that has been covered comprehensively in this law to cover for a witness.
So just one more question on this segment, and we can go into the reforms aspect. This is a procedural question that I want to clarify with you. Now, evidence that is being brought into courts, I think you touched on this in the first segment, needs to be revealed summarily before trial starts. Is that the case, or can there be discoveries as the case goes on? There is a small clarification that I think people will require there.
Yeah, exactly. Our system not being inquisitorial like these movies that I spoke of, you cannot have investigation at the trial.
Within the trial.
There is a separate section for investigation where the magistrate could assist the investigator to investigate the offence, like taking samples. If the accused refused to give samples of his hair or whatever, then court can intervene and get samples. All that is there. But moment you file the charges, the investigation stops from there. And then the trial begins. There you cannot have fresh investigation. And that's exactly what adversarial system is done. So that is something debatable, and that's how it is.
Yeah, I think that's something we can really discuss within our next segment, where we talk a bit about the reforms, about the new sort of evidence that have been identified. We are in conversation with President's Counsel Prasanthalal. Alwis, stay with us as we go to our last segment.
And I'm a legal assistant. My question is on reform. How should the laws related to evidence be reformed to fit the 21st century?
Welcome back to Law, Land and Liberty. We are in conversation with President's Counsel Prasanthalal Alwis. Sir, within these segments, I think we have given an understanding of what we are really talking about when it comes to evidence law. Now, the way forward from this point onwards, because in relevance to the initial legislation, as you said, it's comprehensive, but just looking at the date, you will see that there were a lot of improvements that happened from that point onwards, because it's close to over a century that the legislation has been put into play. Based on that, sir, my first question is, how have we been inclusive of the more novel forms? Because more than electronic evidence, also now we see the next few stages coming in, like sort of cryptocurrency coming into play, the sort of transactions that are occurring, the efficiency of the transactions that are occurring, and if the law is not capable of being in par with that, we're falling behind, and that really opens a huge window to a lot of other issues that may arise pertaining to how money will be laundered, and again, a number of issues that may arise. So what has been the role of either state or Sri Lanka as a whole in being inclusive of these developments? Where should we be going? If you can just give an introduction to this segment, I think we can improve from that point.
Yes. Now, as I said before, let's take one by one electronic transaction.
Yeah.
As I said, the Act came in 2006.
Yeah.
So we have already gone through many years.
Yeah.
But as you know, Danidu, for us to be binding, there must be a Court of Appeal or a Supreme Court judgment.
Exactly.
Unfortunately, there are hardly any, not much development on this. But take India, they have gone very far on this electronic transaction with the same evidence ordinance.
Okay.
I'll give you one example. We had an issue with COVID, whether you have to take evidence in the presence of the accused or in the presence of the judge. That's how Criminal Procedure Code says.
Right.
So we had an issue here. We had the accused in some other place, and evidence is being led on Zoom or virtual basis, whether it's present. But by that time, in the Dr. Rifai case, in state of Maharashtra, said, if you're watching a live, now that's very relevant to us, live a cricket match, that means you are in the presence of the match.
Right.
Now, yesterday we had the T20, we were in the presence, it was in India.
Yeah.
So they argued, they said that you have to take the law development into consideration. So when you are having a live watching a match, you are in the presence.
Yeah.
And they said if you are looking at an animal through a binoculars, you are in the presence of that animal, though what you see is through the binoculars.
Yeah.
So they went and said, we have to now change with the thing. Sadly, we have not yet gone that far.
Okay.
Probably it has not ended up in the court. Actually, that's a fact.
Yeah.
So we have to have a lot of development with the modern technology. That is, judges must be made aware of the law, lawyers must be made aware of the law, and if we can have that development, this act would be, as I said, dinosaur will die in the natural death, but the truth, the objective of finding the truth will be there. Right. Another factor which worries me all the time is accused is given a right to give a doc statement in his evidence. Doc statement is at the end of the case, he can get into the accused doc rather than in the witness box and make a statement. And our law says that is evidence. Now, that is not in the evidence ordinance, but that's customary through the whole system of British law or the Commonwealth law. Yeah. We have accepted that. Yeah. Now, that means there is something special right given to him where he need not take an oath of saying I am truth or not, which is normally there for normal witness. Right. He cannot be cross-examined by the other party. But the law says with those infirmities, still that evidence has to be taken. So I find as a prosecutor, even as a defense counsel, though it is sometimes beneficial to us, see a disparity there. Like Singapore, though it's a Commonwealth country, got rid of dog statement.
Right.
So we need to look at that.
Right.
The other aspect is confessions.
Okay.
I mean, confession made to a police officer is out, confession made to a person in authority has to go through inducement, threat or promise, but in the Terrorism Act, PTA, Prevention of Terrorism Act, under section 19, that is admissible provided it is inducement, threat or promise, which is very correct, because in a kind of a terrorist situation, you will not have independent witness coming to give evidence against a terrorist. So your confession can be used provided it is without inducement, threat or promise. Now why cannot we have that in all the confessions made to a police officer? You can see in the movies in England, they say this evidence can be used against you. Whatever you say. Now that is warning is given.
The Miranda rights again.
Exactly. And that is admissible provided it is truth. So why can't we go through that process of a confession rather than being totally shut out? And to have a process where to test in a voir dire, we call it a separate inquiry, whether it is without inducement, threat or promise, and therefore it is truth. So these are the dramatic changes we need to look at it, because people are losing faith sometimes. People feel that we are more tending towards the accused and we are more rule based rather than finding the inquisitorial. So these are the few changes that came into my mind for your question.
Right. So just to develop on that a bit more, I think what you have been pushing for in multiple occasions is to get the inquisitorial sort of like standards involved in our system of like the adversarial method that we currently follow. In developing on that, sir, do you believe that we need new legislation in place that is separate to what we have been talking about, that is separate, completely separate to the evidence ordinance that is in play, or are we capable of developing on the things that we have right now? Because this question comes to light because I think you said there's only one edition that has come about after the 19th century enactment. In such an instance, and after that the developments have happened mostly through common law, if I'm not mistaken, and we don't see, I think within your practice you have witnessed this, that a lot of these cases don't come up to either the appellate or the Supreme Court levels because of the exhaustion that happens throughout certain areas. Do we need more sort of legislator to provide a better mandate to the lower courts, to the magistrate court maybe? Because one thing I want to highlight here is, now we see when a crime does occur, the judge in that specific area would go there and witness the area. It is part of the entire investigation process. So we have that kind of hands-on sort of investigation aspect that is involved in all this, which may not be present in other countries. So those procedural matters, do you think that we need to change, which is sort of like keeping the evidence ordinance aside? What are the changes that need to come?
Exactly. Now, in the interest of justice, like the computer evidence, the court is still allowed to do that. And the court is allowed, we can't take, in the magistrate courts, police statements cannot be taken unless it is the first complaint against the person. So, but in the interest of justice, court is given the power for us to peruse a statement. Likewise, there are interesting safeguards for justice, but I think we need to make law changes. I'll give you one interesting classic example, Payment Devices Fraud Act. That's relevant to credit cards. Now there are presumptions. Good example would be that, say, I have a credit card and I have changed my address or my job and I have not informed the police, and I have not the amount paid in full. Full, very interesting. Full, and I don't inform the thing. There is a presumption that I am there to deceive or cheat. Now that is something interesting. Right? That is safeguarding the payment devices fraud system, because if you want to have a clear country with a lot of safeguards for credit card, that's what people who issue cards wants, a strong system. Now that is unbelievable as we discussed. We are presuming things. Where the earlier scenario was prosecution has to prove these factors, whereas now there is a presumption. And I have to say, no, I did not, want to cheat. So likewise, there is a lot of changes happening in the modern world. Corporate people can't wash their hands. Now I'm a corporate director, right? Whatever happens in any place in the country, I am liable. Say Mosquito Breeding Act. If there are mosquito breeding in one of the companies where I work in a branch in Galembedunu, I am not aware, but I am liable, because we directors has to be take due diligence. That's what the section says, so that we take every step not to do that. So the law has developed to encompass and so that everything is taken care. So legislature must come in and change these things, because there are, as I said, the doc statement, beyond reasonable doubt, all those are Ellenborough principles are not section based, rule based.
Right.
So we may need a lot of interesting deliberation on change of law by statutes, by the laws.
Right.
So that make it black and white.
Right. So I think as a last question, I think we covered a lot, but I feel like we can take this discussion for many more hours forward. But I feel like I can't let you go without asking a question on the just to draw from your experiences within this field. I think which is why this discussion has been so rich so far. You spend a lot of time on the ethics aspect of this. You teach, you groom younger law students, even the legal fraternity as a whole. When it comes just in relevance to the law of evidence, where do you see maybe disciplinary issues pertaining to either state counsels or even defendants, as in litigators on the other side, that we as a fraternity or as what you would say to a law student, even to younger legal officers, where do we need to improve on? What are things that we need to be careful of when it particularly comes to our way of handling evidence or submitting evidence?
So may I first, as to evidence submission,
Yeah.
When you are a lawyer, right, there is disciplinary committee by the Supreme Court and the Bar Association, one panel I am a chairman. So I see, this evidence. You have to be very diligent about your client. You have to go deep into the case and find out all material that is there for your accused and against your person. Yeah. And then, of course, we as lawyers are not bound to lead evidence of which other party must do. I mean, if I am for the accused, I am not supposed to lead evidence for the prosecution. Exactly. That is breaching my code, ethics. Yeah. Yeah. So I have to present every evidence that is there. And I have to be diligent of taking a proper defense. I have to be diligent in objecting to irrelevant and admissible things. So as a lawyer, because my client is not aware, he has no law background, especially in the adversarial system. Yeah. It is totally depend the justice on me, the lawyer. Yeah. You one day, a lawyer. Exactly. Right? So in that kind of a context, we have to be very diligent. We have to be very careful, very work a lot of hard to get all the evidence for and against and present the case. And if you don't do that, there is disciplinary code definitely.
Right. I think that's a very positive message to end this on. I think the kind of messaging you're giving there is quite important about what the role and the responsibility of a lawyer is within the current status quo. President's Counsel Prasanthalal, Alwis, that was a very fruitful discussion. Thank you so much for joining me. I hope we can have another discussion maybe soon.
Pleasure and a privilege to be here.
Okay, thank you so much, sir, for joining me. We'll continue this discussion as we go on. President's Counsel Prasanthalal, Alwis, is a lecturer in criminal law. Just to thank you once again. Maybe in the future we can talk more about the ethics aspect of all of this and continue that discussion. Thank you, sir.
Thank you so much.
All right. The law of evidence encompasses one of the most fundamental pillars within the delivery of justice, as it is what dictates the judge's decision. The sensitivity of evidence, therefore, is of utmost importance. Author Stephen James once said, "Follow the evidence to where it leads, even if the conclusion is uncomfortable." That is all from us here at Law, Land and Liberty. If you had missed today's program, you can rewatch the entire episode on our YouTube channel, youtube.com/Derana English. I'm Dhandir Tanwasan. Have a great night.